Welcome to the July 31st, 2022 service event of the NTCOF North Texas Church of Freethought. Well, since the onset of the pandemic, we've been meeting every Sunday by Zoom, except for the first Sunday of the month when we get together at a local hotel for open discussion. That'll be next week. Last week, we had a Zoom presentation here. Don Kraus gave an excellent account and analysis of the recent Supreme Court decision striking down the almost 50-year precedent establishing a constitutional right to an abortion. We don't have a presentation with every one of our Zoom sessions, but we do again today, and rest assured, I would really like to do a lot more. There are many interesting questions connected with the recent Supreme Court decision in the case known as Dobbs, in which all but one of the 7 Catholic justices voted to strike down the historic 1973 decision of Roe v. Wade. Many of these questions are interesting in their own right, and they're not just about abortion. Many of them are really quite quote-unquote religious in nature. Today we'll consider one of these questions, which is that of legislating morality. But before we get to that, let's consider what the NTCOF is about. Too many people think of religion as belief in God, worshiping God, doing various rites and rituals to get right with God, hoping to get into heaven and avoid hell and other supernatural stuff. And we say no. Many religions, especially the Abrahamic religions of Judaism, Christianity, and Islam, obviously do involve superstitious doctrines and dogmas. Many assert even entire parallel accounts of the natural world, anything from a flat earth and creationism to God of the gaps business to a supernatural first cause. Again, we say no, it doesn't have to be this way. North Texas Church of Freethought is about reinventing, reimagining religion. We say religion is just what you think of religion, and the big questions, what are typically thought of as religious questions. What is the meaning of our existence, for example? What is important in life? How ought we to regard ourselves and each other? Where does love and fear, courage, ambition, loyalty, and many other feelings and ideas fit in? What is happiness and how can it be achieved? And while many of these puzzles can be addressed with science and philosophy, their significance, the reason that they are big questions is because the answers are not necessarily the same for everyone. Their significance is truly only realized when they are considered from a personal, subjective, experiential point of view. That is, what is your purpose and your meaning? The traditional religions don't do that. On the contrary, they offer a one-size-fits-all solution that we have found is no solution at all. Our take on church reflects our take on religion. Even though we may come at life in different ways, even though we may come up with different answers, and we may even come up with, in fact, we do come up with different answers at different times in our lives, we share core values. We reject the supernatural. We accept the facts as best we can tell what they are about the objective world that we share, and we are determined to try to live our lives by relying on facts and reason, recognizing that our internal perceptions are our own facts and not necessarily those of others. We call it Freethought, which happily has an historic meaning, usually stated as opinions about questions of religion held without regard to tradition, authority, or established belief. Thought, by its nature, is and ought to be free. Thought cannot be restricted to only certain topics. It has to be free to doubt and question anything and everything. It is a testament to how wrong the traditional religions have gone that we must call it free thought and not just thought. Our religion is doubt-based, not faith-based. It is about thinking more than believing, because belief only acquires its legitimacy from the thought process relied upon to reach it. Our religion, like life generally, and certainly like science, is not an infallible edifice of doctrines and dogmas that must be taken on faith. It is a process of trial and error, and since much of it takes place inside of ourselves, it means that we must look for our errors. Mistakes are not sins to be ashamed of, but opportunities for growth and improvement. They are how we learn to do better. Freethought is a religion of personal growth and development, of self-actualization. For what is life? What is its purpose if it is not to discover and make progress in realizing our ideals? Check out our YouTube channel, our website, and our Facebook page. There are quite a lot of things there. We've uploaded a lot of videos over the last few years especially. Now, as we all know, last month the Supreme Court of the United States, that I will refer to as SCOTUS, reversed the 1973 landmark decision of Roe v. Wade. For 49 years, that decision has protected the right of women to end a pregnancy, subject to restrictions based on legitimate government interests in protecting the health both of women and the children that might result from those pregnancies. In 1992, the SCOTUS Planned Parenthood versus Casey decision ruled that such restrictions are permissibly imposed only after the point in pregnancy when a fetus could survive independently and must not impose what it called, quote, an undue burden, unquote, on women. Justice Samuel Alito, there at the upper left, wrote the majority opinion reversing Roe. He was joined by Justices Clarence Thomas, Brett Kavanaugh, Amy Coney Barrett, Neil Gorsuch, and John Roberts. The opinion was more than 35,000 words, the third longest since 1946, and longer than any other opinion of the term by over 10,000 words. With that in mind, knowing that we have a lot to cover, let us begin. Let me also apologize in advance that my remarks today will be somewhat lengthy. They won't go on for that long, but they're going to still leave a lot unsaid, even with some digressions that I think are appropriate and necessary. So with that said, here's the opening sentence of Justice Samuel Alito's majority opinion in the case known as Dobbs versus Jackson Women's Health Organization, hereafter just Dobbs. Abortion presents a profound moral issue on which Americans hold sharply conflicting views. Now, there is an important clue here to where the majority goes wrong. It is both that word moral and in their acknowledgement of sharply conflicting views. It is said that you can't legislate morality. In the United States, the accepted illustrative example of the folly of trying to do so are the years of 1920 to 1933, when the manufacture, sale, and transportation of alcoholic beverages were prohibited. But if laws are not to be based on morality, on right and wrong, then on what can they possibly be justified? Clearly, fraud, theft, assault, rape, and murder are crimes because they're seriously wrong in some sort of objective way. It can be agreed that these things hurt people in ways that no one wants to be hurt and that cannot be ignored or brushed off as merely rude or inconsiderate. Just as clearly, blasphemy, blood transfusions, and eating hot dog buns or pork, however horribly wrong some may consider them to be, are matters of personal choice. Their wrongness is rooted in personal perceptions and sensibilities only, and not in objective facts and reason. To make sense of this, consider what the Scottish sociologist Robert Morrison MacIver, he was born in 1882 and died in 1970. Here's what he said in his 1926 book, The Modern State. Turn all moral obligations into legal obligations would be to destroy morality. No code of law can envisage the myriad changing situations that determine moral obligations. Moreover, there must be one legal code for all, but moral codes vary as much as the individual characters of which they are the expression. Well, what are we to make of this? We certainly do want legal obligations to rest on moral obligations, but if all moral obligations are not to be turned into legal obligations, this can only be because morality cannot be strictly mapped to legality. It must be that people use the term moral to refer to two very different things. There is morality that imposes the same obligations, the same responsibilities on everyone. Things such as fraud, theft, assault, rape, and murder are universally offensive to everyone. For these things necessarily, directly, forcibly, and very negatively affect other people. Fortunately, very few people have any interest in or inclination to do these things. It's kind of like Penn Jillette says, I can do all the rape and murder I want, and the amount that I want to do is zero. Even the people that do these things, they don't do them openly. And so this is why we welcome and consider it necessary to have laws against those kinds of behaviors. Even then, as we know, people accused of such crimes are afforded the benefits of it being proven that they really did knowingly do those things, and even if they did, they get to explain, if they can, why it was nevertheless justified. And this works pretty well, though not as well as anyone would like, at keeping us safe from dangerous criminals. But there is another sort of morality that is not the same for everyone. Some people follow strict dietary rules, for example. Eating hot dog buns or pork was mentioned. Some people will not eat meat of any kind and would, if they could, impose this restriction on everyone. Others believe fervently that same-sex marriage and even pictures of naked bodies destroy the social fabric. People do all sorts of additional things that others consider deeply wrong and offensive. And when it comes to people expressing themselves, well, there will always be opinions that we dislike. but some people feel that some opinions are too offensive to be allowed expression at all, especially if they are or seem intended to offend. So as difficult as it may be, and clearly it is difficult, we should strive not to pass laws against personal behaviors when there are sharply conflicting views. Now, this is very different than the necessity of passing laws about matters of public policy. So, for example, it is necessary to have police, courts, a military, and many laws that protect the public safety, which is surely the core function of government. Even if there are sharply conflicting views on these matters, decisions must be made about them, and just as surely this is best done through a democratic process. How much money to spend on the police, how many missiles to have, and so forth. But when there is not nearly universal agreement that certain personal behaviors are wrong because they necessarily, directly, forcibly, and very negatively affect other people, then there should be no laws creating legal obligations. Why? What happens when that line of reasoning is not followed? Consider the morality of people drinking alcoholic beverages. Most who drink never hurt anyone. During Prohibition, of course, the consumption of alcoholic beverages was concealed. But how many people were embarrassed by it? How many people felt any pangs of guilt for doing it? How many people turned in their neighbors for it? Yet such consumption, then as now, especially for some who drink chronically and to excess, impairs people in the short term and causes all sorts of very serious health problems in the long term. We all know this. Both of these, in turn, adversely impact a whole lot of people besides those who are doing the drinking, as well as society generally. Like it or not, banning alcohol, when it can be done effectively, really does reduce these harms. In the isolated city of Barrow, Alaska, that's right up on the northern coast of Alaska above the Arctic Circle, there's about 5,000 people who live there currently. Researchers reported in 1998 that there was a substantial decrease, it was about 80%, in the number of alcohol-related outpatient visits when the ban on possession and importation of alcohol was imposed compared with baseline. When the ban was lifted, outpatient visits increased. When the ban was reimposed, the number of outpatient visits again decreased. There are similar studies that you can find out there that, for example, in the early 20th century, when various Canadian provinces banned alcohol, deaths from liver cirrhosis, which is largely caused by alcohol, were reduced. So there's no question but that Prohibition in the USA was well intended, at least in part, and almost certainly helped prevent alcohol-related problems. It did some good. Just remember, too, that it took a constitutional amendment, the 18th, to do it. But there were serious problems with Prohibition, so many and such severe problems with it that after 13 years, Prohibition was ended. It took another constitutional amendment, the 21st, to do that too. It's a fascinating chapter in our nation's history, and there is an entire body of literature dealing with how it all happened. But how many people today ask, seriously, what did we really learn from it? There remain today many restrictions on the sale and consumption of alcohol in the United States and elsewhere. In Texas, there are today 5 dry counties in which alcohol may not be sold. This is a map showing what the county-by-county policies are. Yet today in the United States, drinking alcoholic beverages is generally accepted as a matter of personal choice. It certainly isn't necessary to life, but some people enjoy it. They do it socially in settings where it is accepted and expected. And some people like certain products in certain circumstances. A famous Supreme Court justice likes beer. As is well known, though, some people get into trouble with alcohol. It varies from state to state, but it's estimated that 18% of American adults drink too much. You see here figures that give an idea of the scope of the health and economic costs of alcohol that affect real people. Indisputable persons who themselves have parents, siblings, children, and others that love and care about them. Given all this, it is possible even now to make an excellent public health and morality-based case for restricting and even banning alcohol. Even though some people maybe have good reasons, well, there's so many people that don't, so we should just ban it for everybody. Like with abortion, remember. Yet Prohibition remains the poster child, the object lesson for things going badly when people try to legislate morality. There are many other things that are very offensive to some people who might jump at the chance to ban them if only within a small jurisdiction. Almost anything is offensive to some people, and if the numbers of people interested in or having any desire to do something is small, you don't even need a majority to criminalize it. If something can be made to seem disreputable, so much the better. How many politicians would dare to publicly oppose a ban on pornography or a measure criminalizing adultery? As it is, many have built their success on hatred of gays and fictitious claims that Christians are being persecuted in the United States. But there is something else that is offensive and ought to be offensive to most people and not just a few. It is perhaps even more offensive than any single instance of fraud, theft, assault, rape, or even murder, and that is a society, whether governed by an autocrat, an oligarchy, a democratically elected body, or even a direct democracy, that undertakes to make every moral obligation, or more to the point, everything that anyone who can gain control of the levers of government power may believe is a moral obligation, into a legal obligation. As Robert Morrison MacIver concluded in 1926, to legislate against the moral codes of one's fellows is a very grave act, requiring for its justification the most indubitable and universally admitted of social gains, for it is to steal their moral codes, to suppress their characters. MacIver says it all here. Profound violation of one's person to be kept from following the dictates of one's own conscience, to be kept from being oneself, and to be made into a means to the satisfaction of the moral codes of others. For the core of greater morality, the sort of morality that ought to justify any laws, is to be considered as an end in yourself and not a means to the ends of others. To legislate against a person's moral code is to trespass on who they are. It destroys morality in the name of supporting it. Well, last week, Don Krause cited the 1965 SCOTUS Griswold decision, specifically the concurrence by Justice Arthur Goldberg for his mention of the right to be let alone, sometimes put as the right to be left alone, and the right most valued by civilized people. Griswold was that SCOTUS case out of Connecticut in which restrictions on access to contraception were struck down. But Judge Goldberg was actually quoting Justice Louis Brandeis' dissent in the 1928 SCOTUS wiretapping case of Olmsted. That case was itself later reversed, vindicating Brandeis, because the original decision said, oh yeah, the government can just go wiretap wherever it wants. You don't have any right to that privacy. But that's why today, because it was ultimately reversed and because of Brandeis being right, why the authorities cannot now lawfully place wiretaps without the permission of a court. But Brandeis' dissent, 1928, drew on and developed from an 1890 article in the Harvard Law Review that Brandeis co-authored with fellow Boston attorney Samuel Warren. That article was entitled The Right to Privacy. It is still regarded as one of the most influential essays in the history of American law. Although some have said that Brandeis and Warren invented the right to privacy, they argued that it is implicit in a long tradition of the common law that protects one's inviolate personality from others, especially the government, that otherwise would desecrate the personality. Now that, desecrating the personality, it does sound an awful lot like stealing moral codes and suppressing people's characters, doesn't it? But wait, what is this common law, you may ask? Where did that come from? Who voted for that? Well, it came to the United States from England. The colonists, including the founders, were familiar with it and relied on it, just as did their fellow British subjects back in England. They were all British subjects at the time, remember. Only after the American Revolution, the common law in the United States started out on that basis and slowly began to diverge, and the same is true of the former colonies of Canada and Australia. Common law is what is called the unwritten law. That has gradually been built up over hundreds of years since at least and possibly before the Norman invasion of England in 1066 of the current era. It consists of what previous courts have done in similar cases, so it is also called case law, which is to say court precedents. Stare decisis, Latin for it stands decided. For what would justice be if similar circumstances did not yield similar outcomes? What would justice be if somebody could have an abortion perfectly legally and fine in January of 2022, and then in January of 2023 it was murder? That wouldn't be justice. Not only that, but courts often have had to make decisions where the written laws are unclear, ambiguous, or absent. So judges do the best they can, and for this reason, the common law is sometimes also called judge-made law. Shocking, isn't it? Because it is often said that judges are only there to interpret and apply the law, not make the law. It is said that judges that do more than read the text of laws that have been written for them to apply are activist judges. But if this were entirely true, then the common law would all have to be thrown out. And indeed, if this were entirely true, then judges would not be necessary. Are judges necessary to apply the laws of science? Of course not. Now, there is an important distinction between judge-made law, the common law, and the written law. When judges decide cases and make law, they give reasons that relate either to existing written or previous case law. They don't just decide that it would be nice if something were legal or illegal. So, as we see, for example, the right to privacy is implicit in the common law and also in the First, Third, Fourth, Fifth, and Ninth Amendments, and applied to the states through the 14th. What judges do not do, as legislators do, is to decide what government policy should be on some issue. Remember, some of those very divisive things on which people have sharply conflicting views, but have to be settled some way, and that's what legislators do. They enact laws to, for example, reduce carbon emissions, or make child daycare more accessible, or protect endangered species, or conserve energy by setting a national speed limit of 55 miles per hour. Remember that, some of us. How is it that the right to privacy was not explicitly recognized until Brandeis and Warren's 1890 article and thereafter? Well, for one thing, it was always there in the overall effect of the common law in protecting people's private sphere of action, even if attention had not been drawn to it. The right of the people peaceably to assemble, for example, part of the First Amendment, has got to mean the freedom to associate with whom you want and in ways that are agreeable to you. It doesn't explicitly say so, but this right does not leave room for the government to require you to report, register, pay a tax, or otherwise dictate the terms of your membership in any group with which you may associate. The Third Amendment prohibits the stationing of soldiers in your house without your permission, at least, quote, in time of peace, unquote. How many people today appreciate having that as a guaranteed right? But again, the clear intention is that the government may not disrespect your zone of personal autonomy and privacy. The Fourth Amendment's right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures is as explicit as it gets. Yet, as mentioned in the 1928 Olmstead case, SCOTUS initially ruled that wiretapping was not in violation of that right. This suggests another reason why the right of privacy was relatively late in being recognized. For government authorities, for a very long time, simply did not have the resources or the technologies required to significantly invade people's personal spaces and freedom of action. That changed with the Industrial Revolution, and especially with the invention of the telegraph and then telephones and recording devices. By the time of Brandeis' dissent in the Olmstead wiretapping case, Brandeis could credibly write of a police officer's, as he said, quote, reading the papers of someone without a physical seizure, without his even touching it. A few lines later came this. The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They knew that only a part of the pain, pleasure, and satisfaction of life are to be found in material things. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. They conferred as against the government the right to be let alone, most comprehensive rights, and the right most valued by civilized men. To protect that right, every unjustifiable intrusion by the government upon the privacy of the individual, whatever the means employed, must be deemed a violation of the Fourth Amendment. Within a decade of Olmstead, the Nazis were using the latest information technology to track down, imprison, and murder those they saw as their enemies. The Holocaust would not have been possible, not at the scale it was carried out, without these new innovations. And as we know, at least we have been warned, things are even worse today. Indeed, largely because of the internet and ubiquitous terms of service, those contracts of adhesion, it's a little bit unequal, isn't it, when you need to either click the box or continue to live in the 19th century. Private companies can now know almost everything about us, and they can and do hand it over on request to the government and for a price to anyone else. One wonders how long the right of privacy, to be who you are or would like to be, to live by the moral code that seems best to you, and to express your own character. One wonders how long that will last. Now, it may happen that legislatures don't like the results of the best efforts of judges, even of the Supreme Court. When that happens, legislatures can do what courts cannot. They can pass laws, subject to the approval of the executive, that override case law. If the issue is constitutional in nature, of course, then the Constitution may need to be amended. And we saw that happen with Prohibition. Then, as new cases arise, judges must decide how the new written laws are to be interpreted and applied in the context of the overall body of both common law and statutes. So in this way, there is an ongoing conversation between the courts and the legislatures, and at the national level, this goes on between the Supreme Court and the Congress and President. And we see this right now in efforts that are now underway to try to codify same-sex marriage, a little bit late in the game, into a federal statute in anticipation of the Supreme Court next reversing its decision in Obergefell. As it is, the conversation from the Supreme Court now to Congress is go ahead and ban abortion nationwide. Now, Justices Alito and his accomplices were careful to say in their majority opinion, our decision concerns the constitutional right to abortion and no other right. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. Well, that's kind of like the disclaimer in satirical and spoof TV shows that say, oh, we're not, nothing we're talking about here has to do with anything else. Well, of course, those other precedents stand, just as Roe did until a month ago, but there's no reason, and Alito and his accomplices give no reason to suppose that many other cases establishing important constitutional liberties will not be overturned. And when they are, it will probably also be as a result of carefully crafted legislation designed to be challenged, which then work their way up to SCOTUS, just as Dobbs did. At least Justice Clarence Thomas had the courage to be honest in his concurrence, saying, in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell, because any substantive due process decision is demonstrably erroneous. We have a duty to correct the error established in those precedents. Now just look at that for a moment. Ask yourself whether the U.S. Senate would or should confirm a nominee to the nation's highest court if they said that during the confirmation hearings, or if they said more generally that they had a laundry list of previous cases that they would like to have reconsidered and correct the error. No? Because it would show a shockingly unacceptable lack of impartiality? Oh, but once the nominee is confirmed and assumes a life appointment to the SCOTUS, then they can not only talk like this, but write this sort of thing in their official opinions. Thomas went on in his Dobbs concurrence to write of the dangers of Americans having too many constitutionally protected rights. Oh, that would be a terrible thing, because after overruling those demonstrably erroneous decisions, he wants to revisit all these other myriad rights. Oh, there's just too many rights. It's too many of them to even keep track of. It's awful. It makes it too hard for the government. Is this conservatism now? To burn to the ground all the constitutional case law of the last 100 plus years and replace it with whatever Justice Clarence Thomas has in mind? And we can only speculate about the sort of world we would be living in if that happened. For what it is worth, Justice Clarence Thomas, along with then Chief Justice William Rehnquist, joined Justice Antonin Scalia, remember him, in dissenting in the 2003 Lawrence case that struck down Texas anti-sodomy laws. At that time, Justice Scalia indignantly wrote, state laws against bigamy, same-sex marriage, adult incest, prostitution, masturbation, adultery, fornication, bestiality, and obscenity are likewise sustainable only in light of this previous case they call Bowers, which upheld Georgia's anti-sodomy laws and then was reversed by Lawrence. These are laws based on moral choices. Every single one of these laws is called into question by today's decision. The court makes no effort to cabin the scope of its decision to exclude them from its holding. Did you think that the SCOTUS was the guardian of American liberty? Did you think it was the last line of defense against tyrannical government? If you did, you thought wrong. Justices like these have their way. Americans will need to, in future, not only keep track of when it is okay to water the lawn, but in what manner and circumstances it is permissible to masturbate. As awkward as it may be, future SCOTUS nominees should be closely grilled on these matters. Of course, we now know that they can just lie and get away with it, as Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett did. So that's a digression. Is there any reason to suppose that abortion is special or unique such that these other things that Thomas would like to see struck down too are not actually in danger? Well, nothing, no matter how similar, is exactly like something else. That's the problem arguing with somebody who is arguing in bad faith when you try to use analogies. Well, that's not exactly the same. But if you are an anti-abortion zealot, then for you it is special and unique because of your fervent belief that a fertilized egg and all of its products are people, just as if you are a Jehovah's Witness, then a blood transfusion is also special and unique. And this is all fine, but remember, we're talking about legal standards here that must necessarily be the same for everyone, not personal opinions or religious doctrines to which some subscribe. Abortion is distasteful, but so are a lot of other things for some people, as we know. Believe me, there are lots of distasteful things in medicine. Abortion is distasteful in a generic way, inasmuch as, contrary to what anti-abortion zealots insist, no one has an abortion for fun. No one undergoes root canals or brain surgery for fun either, but people have these things to achieve important goals. Now, some people do things for fun that others, maybe even most people, find distasteful. Things like tattoos, piercings, objectionable sex or sex with the wrong gender, or promiscuous sex. Looking at the long list of things widely considered disgusting and seeing how many of them are connected with sex, one would think that sex is just altogether a terrible thing. And as we know, the dominant supernaturalism in the United States, Christianity, considers it original sin. Other things are maybe not so much distasteful as just things most people won't do, but others enjoy. Base jumping, scuba diving, and motorcycling, for example. But isn't abortion still like all these things in that it doesn't hurt others? If others take offense, that's their problem. If others don't like it, then they shouldn't do it. And no one should hate and judge others and their circumstances about which they know nothing and that are none of their business. As we know, anti-abortion zealots insist that abortion is not at all like this, especially the first point, which brings us to that second sentence of the Alito's majority opinion in Dobbs. They wrote, "Some believe fervently that a human person comes into being at conception and that abortion ends an innocent life." Well, this is quite true that this is what they believe. This is why the anti-abortion zealots say that abortion is murder. That's their fervent belief. It is, in fact, quite obviously the fervent belief of the Dobbs majority that struck down Roe. As Don pointed out last time, the majority opinion, in addition to repeatedly and approvingly citing the Mississippi law describing every pregnancy as an unborn human being, after uncritically saying that the Mississippi legislature had made a factual finding, that's what Alito et al. Said, factual finding, quote unquote, that every pregnancy is, quote, an unborn human being. They went so far as to dishonestly equate Roe's referring to potential life as an unborn child. This is literally the slogan of anti-abortion zealots who talk about the unborn as if it were just another category of people, just like the undocumented, or the uneducated, or the uninsured, or the unemployed. Here is an unsprouted oak tree. It has the entire genetic complement of an oak tree, and it is a unique individual, which, if it gets what it needs, will grow into a mighty oak. You can see that just by looking at it. So why go lumbering in the forest when you can just use a few dozen of these to build your home and all your furniture? And here is an unmade apple pie. Thank you, Catherine, for that wonderful suggestion. Again, the essential character of the most delicious apple pie is right there. And this, well, never mind what it actually is. The point is that these poetic ideas are not facts. You are welcome to see an oak in an acorn, or you may prefer to see an acorn in an oak. An apple may become apple pie, or not. And a fertilized egg may or may not give rise to someone who finds the cure for cancer, or invents faster than light space travel, or maybe instead a mass murdering corrupt political leader. But wild speculations such as these do not justify legislating against the moral codes of one's fellows. When the Dutch lens maker and amateur scientist Antoine van Leeuwenhoek looked at human sperm under his microscope in 1677, he saw for the first time something unexpected. Shortly after, the Dutch mathematician and physicist Nicholas Hartsucker went on to see these tiny people in spermatozoa in each one. Well, it took many more years for the truth to be sorted out, and it is still being sorted out. You see an ovum there at the top left, egg. Spermatozoa on the bottom left. There's a fertilized egg, a zygote at the top right, and a two-cell embryo on the bottom right. But none of these are people. In fact, before an embryo begins to separate into definite tissue layers, what are called the ectoderm, the mesoderm, and the endoderm, it is not an individual at all, but an aggregate of cells that we say are totipotential, having the potential to turn into any cell type, including a whole organism. This is how identical twins happen. If we separated those two cells there at the bottom right, might get identical twins. And the opposite can happen as well. Two embryos might combine, might fuse and grow into one fetus, which is a chimera composed of two different cell populations. So if a fertilized egg has a soul or possesses personhood, when does that second soul or second personhood happen in the case of twins? Or in the case of someone who is a chimera, do they have two souls? Are there two persons in one? And what happened to the other soul or person? And if those waters are not muddy enough for you, sometimes an embryo develops into everything but the tissues needed to become a fetus. This is called a blighted ovum, or in more technical terms, an anembryonic pregnancy. Where in those cases did the soul or person go that we are assured by zealots was in the fertilized egg? This is not a person either, but it used to be a person when the brain was alive. Even a living brain or having brain waves, though, does not make you a person. All of us are people because we have brains that, as a result of perceptual inputs from birth on, created the structure and function of the neural tissue capable of carrying on the activities that make us who we are and give us the ability to experience ourselves. The fact is that human life does not begin. There is a human life cycle. Just look at this image and realize that there is no scientific reason to single out any one of these stages of the human life cycle as being, quote unquote, a person. Not from a scientific point of view, or to say when life begins. But that's because this is biology. It's not psychology. It's not sociology. It's not philosophy. And really, it is ironic, isn't it, that anti-abortion zealots who are overwhelmingly motivated by religious supernaturalism and supposedly believe in immortal souls and the like should locate our humanity and what it means in things like protoplasm and DNA. There is no beginning of human biological life. There is a beginning, though again, no bright lines in each of our individual personhoods, but it arises after we're born and not before. Anyone who has raised children knows this. Well, we'll definitely have to have a future service on personhood because it is a very interesting subject in its own right. But for now, it need only be said that there is no need for there to be any bright lines as to when personhood begins when it comes to abortion. In fact, the focus on personhood is a red herring that is exploited by anti-abortion zealots to sell their absurdities. You can find a lot of red herrings when it comes to religious supernaturalism. Our own Texas Senator John Cornyn recently spewed this nonsense in attacking a witness at a hearing. Infanticide is murder, right? So that can only be because a newborn is a person. So then why, it is asked, is killing a full-term healthy fetus one day before it would have been born, which they claim happens all the time where abortions are legal, why is that not murder? And the answer is that while reality often does not supply bright lines, the law must draw them. But in drawing them, it does not change objective facts. It only creates legal conventions and legal fictions. So, for example, when a child is tried as an adult for some crime, it does not make the child an adult. The fact is that murder is a legal term, and regardless of the terms, both infanticide and the killing of a full-term healthy fetus are wrong, at least in our society, even if neither is the killing of a person. Deliberately causing the death of a dog or cat can also be wrong, even though there's no question that those animals are not people. Infanticide is not something that has likely ever been considered a good thing, but at times it was practiced as the least bad of the alternatives. Here we see some Arctic terrain. You may consider it beautiful, but imagine trying to survive in it. Suppose that a pregnant woman and a small band of people living in such conditions, say the Inuit, what we call the Eskimos, suppose a woman gives birth, and then maybe she dies of complications. That was a common occurrence in the bad old days, which is to say during most of our species' existence. If there are no other lactating women available to feed the baby, there's literally no way to take care of it. Or suppose the infant has a medical condition that prevents its feeding properly. And there are such medical conditions, many of them. What is that family or group of people without access to modern medicine to do? What would you do? We should be glad that, with the fruits of modern science and technology, we never even give a thought to such problems. In fact, we enjoy the luxury of thinking of infanticide as a barbaric practice of our distant and very immoral ancestors. This slide, pulled off the wonderful internet, brings up other issues why the Eskimos practiced infanticide, because their living situation, the demands on their survival were very different than ours. We may also compare various situations to discover how they affect our way of thinking. So think, for example, of someone who brutally murders a neighbor, maybe also torturing them as they do so. And then think of a pregnant woman who takes some medication and begins bleeding and passing tissue. Do we think of these two people in the same way? Which one would we be comfortable with having as a friend? Which one would we be okay with babysitting our children? If an embryo or a fetus is morally equivalent to the rest of us, there should be no difference as to how we think of these two situations. Or let's tone it down a bit. Let's say instead of murdering people, someone has a completely harmless hobby of they like to construct life-size and lifelike human dolls and then devoting many hours pretending to torture and murder them. Would you trust that person more than a woman who had had an abortion? How about a physician who performs surgical abortions? Is it reasonable to think that such a physician is just as dangerous and morally corrupt as a mafia hitman or a serial killer? No one in their right mind would think that, but that's what anti-abortion zealots say that they fervently believe. For the sake of argument, let's assume that a human being, a real person, gradually comes into existence between 1 and 4 years of age as the brain becomes organized, begins to recognize objects and others in its vicinity, acquires the ability to purposefully move about and interact with its environment, learns to comprehend and speak a language, and then rapidly outpaces the cognitive abilities of the most intelligent household pet. It appears that something like this is actually what happens. We can nevertheless find reasons to see the deliberate killing of infants and small children, and indeed any fetus capable of living independently, as wrong, even though they are incapable of any of these things. And this is because, for one thing, even extremely premature newborns can behave as newborns must in order to survive. They're viable, that's what they call, or have viability, for they breathe, cry, digest, urinate, defecate, and most importantly, anyone can care for them without being physiologically imposed upon. Surely, even though there are no bright lines when it comes to personhood, to draw it at the point when a fetus can survive independently is way, way before it happens. So not a bad place to draw a line if you're going to have to do so, which the law does require us to do so. Even if a newborn is not a person, it has far more chance of becoming a person than any fertilized egg. Most fertilized eggs don't turn into people. If they were people, we would have to expend the entire budget of the National Institutes of Health trying to figure out how to prevent most of those fertilized eggs from not turning into people. What happens to a newborn will affect the person it may ultimately give rise to, and this is really the importance of the notion of potential life that the Roe decision referred to as giving the government some interest in protecting. If I have a pool in my backyard, for example, I might be required to fence it in and be sure that any gate will self-close and self-latch. There is such a requirement in Texas. Because even if I don't have any small children who could fall in and drown, there is the potential for someone else's child, any child, to wander into my yard, fall in, and drown. Many laws are there to help ensure the safety of a potential person, someone who potentially may otherwise be harmed. How about substances that cause birth defects? Manufacturers and marketers of such substances may be liable for the expenses and sufferings of people who must live with those birth defects that occurred well before they were born and maybe even before they became people. Even if the birth defects happen as a result of one or both parents' exposure to the substance before a pregnancy ever happens, those responsible for the exposure incur liability. But on the sort of silly logic, quote unquote, of anti-abortion zealots, this could only be the case if eggs and sperm are also people. This should make it clear that there is much more to it than anti-abortion zealots would have it. And even if a human person comes into being at conception, it does not follow, as Alito and his accomplices assert, that abortion is the unjustified murder of that person. So surely the next sentence of the majority opinion would acknowledge such views, right? They're starting out and giving the lay of the land, especially since part of the 1973 Roe decision, here's from the Roe decision, that the word person as used in the 14th Amendment does not include the unborn. This is in accord with the results reached in those few cases where the issue has been squarely presented, and Roe cited many cases. Now, the majority knew this was part of Roe's holding, and they knew that in overruling Roe, they were also striking down this rejection of zygotic, embryonic, and fetal personhood as well. But while they do refer to views of personhood in a footnote, they do not address it directly. Well, it wouldn't serve their purpose to do that. They're thinking ahead to a longer-range goal of conferring personhood on fertilized eggs with another decision on a future, carefully crafted case that is no doubt already in planning. Justice Thomas is not the only one who anticipates what is now beyond the horizon. No, the second sentence of the opinion is this. Others feel just as strongly that, third sentence, I guess, others feel just as strongly that any regulation of abortion invades a woman's right to control her own body and prevents women from achieving full equality. Really? Who, we may wonder, are these others who object to any regulation of abortion? Dobbs' dissent of Justices Breyer, Sotomayor, and Kagan never expresses a view that there should be no regulation. There has been, of course, opposition to the anti-abortion zealots' dizzying panoply of restrictions aimed not in any interest of the government as outlined in Roe, but at simply making abortion as difficult and burdensome as possible. But there has been no movement since 1973, none, to eliminate the sort of regulation that Roe allowed as appropriate. Notice also that as far as Alito and his accomplices are concerned, these others only feel that a woman has a right to control her own body. It's just an emotion. These others aren't really convinced of it. They don't have any reason, any facts or arguments to support such a ridiculous view. After all, as Justice Alito and the others go on to explain later, such a feeling has no basis in history or tradition. And why would it, since history and tradition is pretty much the story of women as breeding machines owned by men, as inferior to men, as being governed by emotion instead of reason as men are, and on those grounds, not allowed to own assets, sign contracts, or vote. The 19th Amendment allowing women to vote in the United States was only certified on August 26th of 1920. That was 100 years ago, a couple of years ago. I don't remember much of a big thing being made of it. But this is a fact that the majority supposes irrelevant to their analysis of the history of abortion laws going back to the 13th century. In fact, at least since the end of the Second World War, bodily autonomy has been one of the four pillars, and arguably the most important pillar of medical ethics. It is why informed consent and informed refusal is first and foremost when medical treatments are proposed, provided, or refused in the context of medical care. It's no accident that the worst episodes in medicine gone wrong, things like the Tuskegee syphilis study, MK Ultra, horrific experiments done by Nazi doctors, and many other things you probably never heard of, including people being injected with radioactive materials without their knowledge. All of those things involve violation of the principle of bodily autonomy. But the Supreme Court now rejects all that, at least when it comes to pregnant women who will now have the status of children or incompetent adults subject to being regarded as baby-making public utilities. And here's the fourth and final sentence of the first paragraph of the Dobbs majority opinion, striking down Roe. Still others in the third group think that abortion should be allowed under some but not all circumstances, and those within this group hold a variety of views about the particular restrictions that should be imposed. Look at that, they have a variety of views, but they're not necessarily sharply conflicting. Isn't that interesting? In other words, more or less, the 1973 Roe decision, but also importantly, the essence of the medical standard of care. For contrary to the delusional claims, which it must be remembered anti-abortion zealots really believe, that full-term healthy fetuses are sometimes, if not routinely, chopped up in what they call partial birth abortions, such things simply do not happen. A termination of a full-term healthy pregnancy is called a delivery, or if you prefer, a birth. And the circumstances will always dictate what is done when it is not a full-term or even a very preterm healthy pregnancy when the fetus stands a good chance of survival. Let me give you an example. A lethal fetal malformation is discovered early in pregnancy. The mother's had previous babies delivered by cesarean. In the first and early second trimester, this kind of problem can be managed with what is called a D&C or a D&E, the dilation and curettage or extraction to remove the tissue. And this is the same procedure that's done in cases of spontaneous abortions or when early pregnancies, the embryo fetus dies inside, what people call a miscarriage or stillbirth, an abortion in which God is the abortionist. Same pregnancy allowed to progress further, which is inevitable when abortions are prohibited with almost no exceptions as here in Texas, would have to be managed with another cesarean. The result in both cases is a dead fetus. But in one case, the woman does not need a hospital stay, does not have to have major surgery, does not have to have trauma to her uterus and other internal organs that could endanger her health and future fertility, and does not have a prolonged recovery. In the other case, she's forced to bear all of these. I have been there and seen this exact scenario happen. It happens. All because of ignorant and unthinking anti-abortion zealots and their corrupt politicians and judges who know better. Everything depends on the extent of the particular restrictions and the intentions with which they are imposed, of course, as far as abortion is concerned. But there are three more central principles of medical ethics. Beneficence is the obligation to act for the well-being of the patient, or as the case may be, a patient and her fetus, if it could survive, right? That's why viability is important. Non-maleficence is the obligation to do no harm. And justice is the duty to be fair, to treat people equally and make use of limited resources to do the most good and the least harm. Of course, it all gets a lot more complicated than that. Medical ethics is its own academic discipline. They have their own journals, and as medical understanding and practice changes, new puzzles in medical ethics continually arise. The law, by contrast, is a rules-based system, and it is, for this reason, totally unsuited, and the courts much too slow to be of much use when decisions must be made. The only legal principle in such situations is the duty to act, quote, as a reasonable person in the same or similar circumstances would, unquote. But as we know, when it comes to religious zealotry, anything goes. Medical professionals may behave reasonably, respecting a woman's bodily autonomy, applying their best efforts to bring about a good and avoid a bad outcome. But if a woman is not close enough to dying when she undergoes an abortion, then someone, or maybe more than someone, is going to be prosecuted for murder. And if a woman throws a positive pregnancy test, and it's not clear if it may be in the uterus or the tube, she's just going to have to wait until that question is settled definitively, by which time she may die from internal bleeding. Who knows? Perhaps the inquisitors will insist that miracles should be prayed for. Maybe that's next. And if no miracles occur, then the prayers were negligently performed, or God is punishing women for their slutty ways. Being forced to give birth will be the penalty for having sex, and the 21st century American Taliban may well say with their great 16th century hero, Martin Luther, women should remain at home, sit still, keep house, and bear and bring up children. And if a woman grows weary and at last dies from childbearing, it matters not. Let her die from bearing, she's there to do it. That's the standard that our Supreme Court wants to follow. So that's the opening paragraph of the Dobbs decision. It only gets worse, but we see in the opening the sort of ideology that drives new SCOTUS majority. It is doubtful that this or any other part of the decision was written this year or even in the past year. I think that's why it was so lengthy. I think that this decision has been ready to go for a long time, all but the portions addressing the minority dissent by Justices Breyer, Sotomayor, and Kagan. Someone somewhere is congratulating themselves on what they think is a masterpiece tour de force of legal reasoning when it is anything but and flies in the face of the last century of progress in protecting Americans' liberties by properly restricting the power of government. What will follow is clear from the closing line of the majority opinion, now the law of the land, and it is this: a matter about which there is nowhere near a consensus about the universal moral obligations involved, and related matters that are intensely private and relating to Americans' privacy, bodily integrity, autonomy, and well-being. A matter about which what controversy there is comes from religious doctrines and dogmas endorsed by the current SCOTUS majority of Catholic judges. That's going to be now, quote unquote, returned, which is to say, thrown back to the political process like a piece of raw meat thrown to a pack of hungry wolves. One can well imagine what the result will be in today's deeply divided nation, some of which the Dobbs minority opinion anticipates, including a national statutory ban on abortion, if certain people can get control of the Congress and White House. One might as well strike down the First Amendment because it has been wrongly applied to venues of communication other than person-to-person speech and the press of the sort that was used in the late 18th century. I mean, that's what the text meant, and leave it, quote, to the people and their elected representatives in the democratic process. Just what this country needs, right? Truly, as Robert Morrison MacIver put it, to legislate against the moral codes of one's fellows is to steal their moral codes, to suppress their characters. What we see in the Dobbs decision is the SCOTUS saying to every legislative body, yes, you can legislate morality, just go right ahead and do it. In doing so, SCOTUS abdicates its role as a check on the abuses of democracy and opens the door to legislation against the moral codes of others and suppression of who people are. Already mentioned was the irony of people whose most fervent beliefs are rooted in the supernatural, claiming at the same time that humanity is first and foremost about DNA and protoplasm. The further irony is that those who fervently believe that all but a vanishingly tiny part of human existence will take place in an eternal afterlife should so arrogantly impose on others' lives in this one life we know. Perhaps the most troubling and hypocritical is that people who fervently believe in what they call free will, which they claim comes from a supernatural source, should so self-righteously act to prevent others from exercising that capacity in making their own decisions about their own lives. But this is how anti-abortion zealots think, I should say fail to think. Would you rather have this man babysit your kids or a woman who's had an abortion? Finally, consider this. Anti-abortion zealots have had almost 50 years to create their fabled culture of life in which no woman would think to end a pregnancy for any reason. But through all those years, they have done nothing to contribute to this. If anything, through their stalwart opposition to government aid programs, they have only increased the incentives for abortion among those most socially and economically distressed. What if instead a U.S. pregnancy force had been established in the wake of Roe? Then they could invite women who might otherwise have chosen abortion. They could have been made an offer too good to refuse, or at least as much pay and benefits, including education, as U.S. military service members. How would this have affected the numbers of abortions over the last few decades? Why did the anti-abortion zealots never push for something like that? Will they support it now that women are going to be conscripted into forced pregnancy and birth? Isn't this the least that should be done for them? Well, of course, no, because, sex. They did it to themselves, and now it's their punishment, such as the contempt and really hatred that these loving Christians have for women in difficult circumstances. No. After almost 50 years, anti-abortion zealots are celebrating and congratulating themselves for no more than, for the first time in our nation's history, reducing Americans' sphere of personal liberty and increasing and magnifying the government's power to intrude into and thwart Americans' pursuit of happiness. It's not a happy message today, but it certainly is food for thought, even if it gives some indigestion. But this is where we find ourselves. Since Roe was handed down in 1973, unfortunately, anti-abortion zealots have controlled the narrative. All the opportunities for codifying Roe were passed up. And now we have a SCOTUS dominated by people who think that The Handmaid's Tale is a wonderful guidebook for the future. The lesson, which previous generations of Americans understood but many today seem not to grasp, is this: liberty depends on us. And it begins not with more division and strife or marching in the streets or attacking government buildings. It certainly doesn't begin with more democracy, more lording the majority lording it over the minority. It begins with participation in the marketplace of ideas. Facts and reason need to be reintroduced into public discussions of abortion and every other issue. We cannot allow ignorant and deluded people to control the narrative without opposition. It's bad for us. It's bad for them. It's bad for our future. I hope today's presentation has given you some ideas and enabled you perhaps to do that participation in the marketplace of ideas and not to let these silly ideas stand unopposed. By the way, this quote is being attributed to Thomas Jefferson, I see on the internet, but it's nowhere to be found in his writings. It's also appearing with pictures and drawings of the late SCOTUS Justice Ruth Bader Ginsburg, and there's no evidence that she ever said it either. But there is this from the Declaration of Independence, which of course Thomas Jefferson wrote. When a long train of abuses and usurpations, etc., it's the right of the duty to throw off such government, which we can shorten to something that's pretty much like that. When injustice becomes law, then resistance becomes duty. So please think about that. Thank you very much and good morning. Bellius facet, that's our Latin motto, which means do better. Reminder of our principles of reason, enjoying life, appreciation, loving what is valuable and important in our lives. Of course, subject to what the Supreme Court now says. Go to our website, check that out, sign up and get the weekly e-newsletter at the bottom of every page. Visit us on Facebook and Twitter. There are the URLs there. You can, if you're watching later on YouTube, you can pause that and go to that. And remember that Freethought is not free. If you want us to continue doing what we've been doing for the last 24, 25 years now, please visit and donate at our website. We depend on your continued support. And you support your own values when you support the North Texas Church of Freethought, because we can do together what none of us can do on our own. A little jokey thing there at the bottom there. You don't have to tithe 10%. We're happy with less. Join us in promoting facts and reason and celebrating doubt. Demonstrate your commitment in being the future that you wish to see. And with that, we'll go to question and answer discussion. So we'll be doing that privately. But everything before this is posted to YouTube, of course, and we hope to have more presentations in the future. Thank you very much.